Good afternoon, everyone who are here with us or watches us online. We continue our work at Ukraine Crisis Media Center, and the topic is crimes against humanity and war crimes. When comes the responsibility? Our guests are Oleksandr Romantsov, Deputy Head of the Center for Civil Liberties, David Donat Katin, PhD in Law, Secretary General of the Parliamentarians for Global Action, and Oleksandr Pavlichenko, Chairman of the Board of the Ukrainian Helsinki Human Rights Union. Good afternoon. I'm Oleksandra Romantsova, Deputy Head of the Center for Civil Liberties, and we created a working group that developed a draft law, the aim of which is to harmonize criminal code of Ukraine with international humanitarian law. The importance of this topic is without any doubt, and for 3 years we have an armed conflict that continues in the east of Ukraine, and the annexation of Crimea, it requires changes to criminal code of Ukraine, because the Rome Statute was not ratified by our country, but Ukraine can, even without ratification of the Rome Statute, it can change its own legislation in order to correspond to international norms and to introduce such definitions that are really necessary. So this is crimes against humanity and war crimes. And in order to represent international importance of this draft law and importance of this draft law in Ukraine, I would like to give the floor to David Katin, and he is Secretary General of the Parliamentarians for Global Action. They cooperate with us in advocacy of this draft law. Please, David.
Thank you very much. It is a great honor for us to be here in Kiev once again. Parliamentarians for Global Action is an organization of members of parliament. So this afternoon we are heading to the Rada, where there will be a meeting of the national group, comprising of more than 20 parliamentarians from most of the major political parties from both government and opposition. And there is a sentiment that is common to all these members of parliament, that there has been violations of international law that have victimized Ukrainian nationals and people lawfully living in Ukraine under the Ukrainian constitution. The Ukrainian constitution, under its Article 9, stipulates that in all its conduct, foreign affairs and relations, Ukraine acts according to international law. Now, under customary international law, genocide, crimes against humanity, war crimes, and the crime of aggression are the core crimes under international law. They are even part of the penal law of many states that implemented the Nuremberg Charter, including the Russian Federation. So there's nothing new here that we are discussing. These are the same crimes that were made punishable after World War II. Why should they repeat today again? Why should victims have no access to justice? Why is the government not sending to the parliament the bill that was discussed already 1 year ago in a very good seminar in the Rada? What is happening to this situation, where we know very well as an international NGO that the only way to fight for justice is to promote the rule of law and human rights. There is no military solution to conflicts that implicate major superpowers. This is not only valid for Ukraine, it is valid for any other situation of crisis in the world. We need to be realistic. Those who hold the nuclear weapon, they cannot be defeated militarily. If they will be confronted militarily, we will destroy the entire planet. We have seen it recently in the debate around the North Korean crisis, correct? Nobody wants a nuclear war. So nobody wants a real war, because at the end of the day, to fight against an enemy with nuclear capability means destruction of humanity. So the only way to go is to win the conflict of laws, the non-armed conflict, the peaceful conflict of making the rule of law prevailing over the rule of force. It may take longer, but there is no alternative. Ukraine is a member of the Council of Europe, is in association with the European Union, is a law-abiding member of the United Nations. The overwhelming majority of states in the United Nations declare the illegality of the annexation of Crimea, for example, and this is a big victory for Ukraine. Now the next step is to make sure that Ukraine fully cooperates and fully integrates itself in the International Criminal Court. Oleksandr stipulated the importance of the domestic implementation. I also like to stress the importance of the acceptance of jurisdiction that already Ukraine did twice. So the ICC has already opened an investigation in the situation, a preliminary examination with some preliminary findings, to be more precise. And one of those findings is that there are international armed conflicts taking place in Ukrainian territory, and because of this international armed conflict, all the war crimes can be applied. There is no limitation to the application of international humanitarian law, regardless of the rhetorics of terrorism, anti-terrorism. Terrorism exists everywhere in the world. It exists in Western Europe, in South America, in the Middle East. Terrorists can be killing one individual, killing 10, killing 100. This is about an armed conflict that every day victimizes thousands and thousands of populations. It's different in scale, in quality, in character. Ukraine already accepted jurisdiction of the court, but has no right because it's not a state party. So Ukraine is already part of the court. Now, last year, when the report was issued by the court on the preliminary examination, as a result, some commentators have said, the Russian Federation declared to unsign or to withdraw from something that they haven't joined, which is the Rome Statute. So they made a declaration under Article 18 of the Vienna Convention that they would not be even bound by their signature not to defeat the object and purpose of the treaty. Very complicated legal language. Moral of the story is this was just a political declaration, no legal effects. The court should continue to proceed with its investigation, but we totally agree with the Center for Civil Liberties, the Human Rights Agenda, and all the Ukrainian NGOs that Ukrainian courts should be given the tools to do domestic trials. There is no need to wait for the ICC. Also because the Ukrainian constitution, I've read it today before to come here, says that Ukrainians have the right to go before competent international jurisdictions after having exhausted remedies in national courts. Domestic remedies. Where are the domestic remedies on crimes against humanities? So there is a gap that must be filled by the parliament, but the parliament is waiting for the government for this draft law to be discussed, and we really hope that this will happen in this legislature. Thank you.
Дякую, пане Дейвіде.
Thank you, David. And now the floor is given to Oleksandr Pavlichenko, head of Ukraine Helsinki Group on Human Rights, who are in the working group on this draft law, in order to tell you in more detail about this draft law and the discussion and the introduction of this draft law to the Supreme Council that is going on now.
Yeah.
Thank you. Good afternoon. First of all, I should say that Ukraine is now facing the situation when Ukraine at the national level, at court instances, could not qualify efficiently some offenses which are connected with the violation of international humanitarian law and qualification of the crimes committed in Ukrainian territory, and they continue to be committed now, is defined under criminal legislation of peacetime. Respectively, there is a need to introduce changes as Ukraine is going on the way of ratification of Rome Statute, and this would require amendments to the Constitution and to the Criminal Code of Ukraine and Criminal Procedure Law of Code of Ukraine, and relevant related legislative acts. Respectively, the draft law was drafted. Oleksandr Romantsov already mentioned it. In this wording, the experts were engaged to drafting it. They were experts on international humanitarian law, the academicians of the Institute of International Relations, practitioners in criminal law, and they took into consideration the findings of the analysis of current problems which are related to the lack of court judgments at the national level related to the cases which are tried these days, and taking into consideration that the Ukraine is going to ratify the Rome Statute, and this would demand amendment to relevant sections of the codes which I mentioned. The draft law has been prepared. So at present it includes the range of legal norms. This draft law amending Article 438 of Criminal Code was prepared, which is about compliance with the Rome Statute, and it provides explanations of the war crimes and humanitarian crimes against humanity and genocide. At the same time, not to do just simple schematic, which is even not applicable, step of transfer, simple titles from Rome Statute to the Criminal Code of Ukraine, and without efficiently working mechanisms of application of it in Ukraine, mechanism of application and enforcement of international law, humanitarian law. The draft law was prepared, which specifics is as follows. First of all, it was necessary to introduce a definition of crime against humanity, and not only to mention them, but also to differentiate criminal liability for crimes against humanity in order to avoid, for example, liability which is not correlated with current sentences applicable for the violation of relevant categories or types of crimes. For example, crime against humanity which is for forced displacement of population, it was subject to punishment of life imprisonment. Article 115, murder, and 291, distribution of pharmaceuticals, large scopes of them, which resulted in poisoning or death. Only those two articles were subject to life-term imprisonment sentence. So this is not correct correlation in sentences. For example, rapists, they were subject to more severe punishments than the persons who committed murders. But we understand that life is more important than freedom. So proportional attitude was distorted. The crime qualification according to national legislation was not correct. This is one of the examples of differentiation in determining the crime and setting the punishment. It was important that the Institute of Group Responsibility, team responsibility was defined, and it was included into the criminal code. A separate item was to introduce to Article 149 the clause on no periods, of no deadlines for responsibility for crimes against humanity. This would mean that they are punishable despite of the period of time. There are some specific items, and there is also a rule of nebis idem. This is about correlation, harmonization of national procedure with the procedures of international persecution for crimes in the territory of Ukraine during the time of armed conflict. And in particular, this is about harmonization with the procedures and sentences of international courts. And in Ukraine, it is envisaged to use universal jurisdictions. This is about the matters which concerns aggressions and crimes against humanity. They should be implemented on the national level, but not transferred for submission to the competence of international court instances. This is what our colleague Donat also mentioned. Several further items are of importance. They are significant. First of all, possibility of in absentia trials. This means that when an individual is not present at the trial, then it could be held responsible via trials in absentia, and this is a novel clause, and it is included in the new bill. And also an important item is amendments to Article 196 of the Criminal Code to enable criminal measures against entities, but not individuals who committed crimes against humanity. When they committed crimes against humanity, these are specific examples. If we look into the wording of this draft, which is being finalized jointly with the Ministry of Justice, it is now subject to registration there. It is more detailed and envisages all factors connected to the implementation of international humanitarian law on the national level, including investigation, court trial, and sentencing of persons who were named guilty. According to the international humanitarian law and other international institutions such as International Criminal Court. Thank you. So I would like to add about the situation with considering adopting this draft law. We agreed with the Ministry of Justice on the support to this bill. It is now undergoes procedure of approval in other ministries. They are providing their comments. Comments more concerns terminology, but not the essence. Today we will have the meeting. Mr. David Katin will have the meeting with the Ministry of Justice representatives and representatives of parliamentarians from Parliamentaries for Global Actions who represent the Verkhovna Rada of Ukraine. A very important aspect is to adopt this bill. The need to harmonize Ukrainian legislation with the international humanitarian law was approved at the beginning of 2015 at the Security Council of Ukraine, and also supported at the cabinet's resolutions and the Parliamentary Assembly of the Council of Europe many times mentioned that Ukraine should do this. So urgency and relevance of this bill is beyond doubt. During further 3 years, Ukraine should adopt norms which would allow and enable to assess the violations and crimes in the east of Ukraine and in Crimea. Before this is in place, our courts can't qualify correctly what is happening in these zones of conflict. That is why the cases fail, and this gives us the situation of impunity. Now please the round of questions and answers. No questions. I have one specifying question. Where journalists and other civil rights activists, civil rights defenders can see the draft law wording at the website of the Center of Civil Liberties, and we also have an English translation, brief English translation for our foreign partners who wants to know the essence of this law, and we hope that upon registration the bill will appear on the website of our Verkhovna Rada. And I have a question to Mr. Oleksandr. In this case, if these amendments to the criminal code are introduced, what to do with the problem of application of the legislation, which should be not can we apply these new norms on retroaction of the law, whether we can punish persons for the crimes in the past, the war crimes and crimes against humanity. These categories envisage liability just according to this procedure. The fact of crime should be punished and the unavoidability of liability should be preserved. According to the national legislation, what is in international law already in place, we should retranslate, we should just transfer this norm from international law into Ukrainian law. This means the term of action which is indefinite. No questions so far. We have one question. Good afternoon. People's Army newspaper of the Ministry of Defense of Ukraine. I have a question. How many war crimes and crimes against humanity have already been registered which are now under investigation? Do you have the numbers? The classification is war crimes and crimes war crimes and crimes against humanity. So this is the case that we do not have this category so far. That is why there is no formal statistical data. In fact, the classification cannot be provided by our law enforcement authorities. That is why this bill is critically needed. I have one specifying question. For those people who do not understand law nuances, we have an ATO in the East, but not the armed war conflict. Would this prevent application of the law? Even if this war is not formally declared, any armed conflict, including ATO operation, is subject to such international humanitarian law. So we need these norms. And when this law is adopted, these norms will be applicable and they will be in compliance with the international standards. So no legal classification would prevent the application of these norms. This would one comment.
Be a very difficult legal concept. Under international law, there is an obligation to prosecute these crimes. You see, Pol Pot, the crimes committed by the Cambodian Khmer regime were tried. Pol Pot died, unfortunately, but the others were tried about 5 years ago for crimes committed in 1974 to 1977. This was not deemed in contravention with the principle of non-retroactivity because this crime exists already in customary international law, at least since 1945 Nuremberg trial. So no violation of the rights of the accused, and above all, this is a right of the victims. The victims can already go before Ukrainian courts, even though the qualifications are not good. They can go before the European Court of Human Rights, denouncing Ukraine for violation of their right to have access to justice. So it can happen that in 10, 20 years, the European Court will condemn Ukraine for millions and millions of euros of compensation and even take measures against Ukraine. I think this is unfair. It would be very unfair towards both the victims and also the state of Ukraine. In addition, the ICC, as I said, it's already looking at the cases. Not only in Donetsk, Lugansk, also in Crimea. And in my view, and it's the view of some prominent scholars, it is already possible that some of the people who could have committed even wider and larger scale attacks and atrocities were somehow looking at what they are doing, especially look at the Crimea situation vis-a-vis certain minorities, could have been much worse. Of course, we cannot prove it. It's impossible to prove something that does not happen, okay? It's impossible. However, eliminate the crime of murder from the national law, and look what's happening in 1 year time. Do you want to do that experiment? Nobody wants to do that, correct? So you keep murder as a crime, even though you are not sure whether it prevents or not for murders to be committed in Kiev, Rome, New York, Paris, or London. Am I right? The same applies to this law. It's not really a legal issue. So our call here is to make sure that all the correct laws are implemented in the national codes of Ukraine so that there is full alignment with international law and there is a complete ability to cooperate with international bodies. So this is really in the self-interest of the government of Ukraine. So we don't really understand why there is some delay to a certain extent. But we are looking forward to also working with the Rada and the government, and maybe we are planning a big conference by the end of next year, so this can create some sort of additional momentum to this issue with parliamentarians from all over the world. We are present in 142 countries, all with democratic institutions, to be invited and come to Ukraine to discuss with their Ukrainian colleagues how to strengthen the position of the rule of law and human rights, both in domestic and international affairs, because we live in an interdependent and globalized world. We have globalized the economy, we have globalized trade, we have globalized mass media, the internet, and so on. We now need also to globalize justice, human rights, and the rule of law, because at the end of the day, we need to better protect the citizens of all countries in all regions of the world. And this is a process that has to proceed, and it will have to invest every community, even those who seem to be now governed by very authoritarian or war-oriented leaderships. There is no escape to this, and we need to continue to promote these values.
Thank you. Якщо маєте ще якісь ремарки.
Are there any more comments? We have one question. Good afternoon. We know that this bill has been supported by the Ministry of Justice, but whether there will be support from MPs and what instruments we can use to get MPs support, whether the international community will support it. David represents the organization which unites parliamentarians for such support, and today in the evening we will have the meeting with parliamentarians who are members of this organization, and international support to this bill is even larger on the international level than on the national level, because they understand better the importance of this law. The importance is understood by parliamentarians from European countries, from Canada. So the question is that the bill has not been discussed in the parliament. so far. So we initiate this process, we start this process, and we hope that the international support and status of this bill would encourage, would facilitate its adoption, because it is very relevant.
Member states of the European Union are parties to the ICC, and this project that we are doing together with the CCL and the Human Rights Agenda, and inviting all the parliamentarians to attend, is strongly supported by the European Union. And in addition, the Rada, the parliamentarians, they already voted unanimously, including the opposition, for the EU-Ukraine Association Agreement, which includes 2 articles on joining and complying with the ICC. So in theory, everybody agrees unanimously. But practical. So we need to really look into that's why the media has an important role to play, to ask the question, why the delay? And of course, as you know, we came on the record last year, 1.5 years ago, when the constitutional amendment on justice came in public, and we were quite shocked by only one line, which was about the postponement of 3 years of the Article 124, paragraph 6. Only the paragraph 6 postponed of 3 years. All the rest was immediately effective for the justice reform. So this is our question, should be your question, why delaying? So it's something that we need to continue to publicize, because I don't think it has any good basis, but of course we are looking forward to hear the explanations given by the authorities. Thank you.
Тож, дякуємо. Сподіваємося на підтримку.
Thank you. We hope for support to this bill in Verkhovna Rada and in the Ministry of Justice. Thank you very much. So we end this briefing, and all other questions, please discuss them off records.